Maxand was a case that started in the Cape High Court, and the legal points involved were essentially whether, in addition to mining rights, you also need any other environmental or land use planning approvals before you can start mining. The Cape High Court found that you do, in other words, that NEMA activities apply in addition to your mining activities, and that you also need to rezone the land if it's not zoned for mining. That then went to the Supreme Court of Appeal. They upheld the point on the zoning issue, but didn't deal with the NEMA point on the basis that they felt it was hypothetical, because the activities which required approval under NEMA had subsequently been repealed. So the SCA dodged the bullet in a sense. The Concourt were then asked to look at the NEMA points in addition to an appeal against the SCA's Lupo point. And the Concourt found that the Lupo point, in other words, the fact that you need to rezone land before you can mine it, is correct, but found that that environmental authorization under NEMA is not required. And the basis on which they found that was that the mining specific activities had not yet been listed under the environmental regulations. The implications are that if existing operations are being conducted on land that needed to be rezoned for mining purposes but hasn't been, then that, in terms of the relevant land use planning ordinance, that would be unlawful. It means that the local authority or an affected party can approach court to interdict you from continuing with your activities until such time as you have the land rezoned to permit you to mine it. For new operations, obviously it means that they can't move onto land despite getting mining rights until they have it rezoned to allow them to mine. If you take the rationale that was applied in the Concourt, which found that the use of land for mining or for under the MPRDA, the Minerals and Petroleum Resources Act, constitutes a land use for the purposes of the zoning scheme regulations. If you apply that same rationale, for instance, to exploration or prospecting, it must also hold water. In other words, it's a land use. Obviously, certain forms of exploration are more invasive than others, but hydraulic fracturing certainly is one of the most invasive forms of exploration. So what that means is that most of that land in the Karoo, which is zoned rural or agricultural, will first need to be rezoned to permit hydraulic fracturing.